Have you ever wondered what might happen to your minor children if you pass away before they do? Well, in this video, attorney Joseph Marra will explain some very surprising facts about this very topic. So please listen now.
The general rule is the other parent, both parents are the parents and natural guardians of the children, even in the event of a divorce. So unless there was some issues involving the divorced couple, some issues of abuse and visitation has been cut off, the general rule is the other parent, whether they're married to the parent who died or not, is going to have custody of the kids. So that being the case, what happens if both parents pass away? Well, that becomes a problem, doesn't it? One way of taking care of that is to have provisions for that in your will. Something you put in your will when your will is admitted to probate. The judge, remember, the judge's interest, as it is in anything involving children, is what is in the best interest of the child. So does that guarantee that whoever you name as guardian is going to be the guardian? No, it's not a guarantee, but chances are that's what's going to happen unless there's pretty strong evidence to prove to the contrary that the person you name is irresponsible and incompetent and unable to care for the child. But the judge is going to examine that. When you name guardians, there's a couple of things you really have to think about. So if people come in and say, oh, well, if something happens to me, well, my sister will be the guardian. Say, great. Is your sister married? Yes. Does she have a good marriage? None of my business, but this relates to your kids. Does your sister have a good marriage? Oh, yeah, great marriage. I really love my brother-in-law. He's a great guy. All right. Well, what happens if something happens to him? What happens if he dies? What happens if your sister and him get divorced? Do you still want your sister to be the guardian? And if some people at that point scratch their head and say, that's a good question. I don't know. Because, my sister now, she stays home with the kids. If she has to go back to work, if they get divorced, if he passes away, will she be able to handle it at that point? I don't know. Well, then you might want to reconsider either, naming your sister and your brother-in-law as co-guardians. And if they get divorced, then go on or if one of them dies, then have a backup. You can do that. But these are the type of things you have to consider. And with everything, you really need to name backups with everything in your will. If you say, I leave everything to my kids, well, what happens if one of your kids dies before you? You got to name backups. I name my brother as my executor. What happens if he passes away? You have to name backups. That's why one of the things I do before people come in to see me is I send them a checklist and I kind of force them to think of all these things. Because they go, well, I haven't thought of that. Well, you're drafting the document. You're 40-something, you're 50-something, you're 60-something. You've never done a will before. It wouldn't make sense to get this all taken care of now and put it in the document. Since you hadn't addressed it before, what are the chances you're going to come back and address it later? Probably not good. Let's address it now.
Thank you so much, Joe, for that important information. And thank you, audience, for watching. If you yourself or someone you know may have questions on this topic, please don't hesitate to pick up the phone and call the law offices of Joseph Marra. They are professional, friendly, and really great at looking at the pros and cons of your situation, coming up with a fantastic strategy, and giving you some options. We look forward to hearing from you soon.